Good evening, YouTubers. I hope you're having a wonderful day. It's Tuesday at 8 p.m. It's our regularly scheduled live stream. I'm so happy to be back. I took a few days off this weekend, went to Universal Studio to the Halloween Horror Night. Incredible experience, but didn't really have an opportunity to put up any videos during those few days. So to me, it seems like I've been away forever, but in reality, just 1 week. As always, this is a live stream. That means the whole point here is for us to have a conversation. So comments, questions, arguments are welcome. It's all about you asking me questions, me trying my best to respond to those questions. Otherwise, this could just as well have been a recorded video. Before we start, let's just take a look at the poll that I put on about 24 hours ago to see obviously what people chose. As you can imagine, you already know what the poll actually was, but it's basically two options. One is about Killstream, obviously the winner here by a relatively small margin. You'd be surprised that most of the time it was maybe within 1 or 2%. The second one was about birthright citizenship. Now, truthfully, the birthright idea was my wife's idea. She thought it was an interesting topic, thought I should put it up. I generally don't talk about political stuff to begin with, although obviously some of the stuff, especially on the live stream, we try to analyze things that while they're about online matters, they all have a political side to them at all. But nonetheless, that seemed like a very interesting topic, and I was looking into it. So I thought that it's something you guys may want to talk to about, but we can always bring it up at a later time. By the way, let me know how this works, if the audio is good, if the video is good. Never quite sure how it's working, and if you look at the last couple of weeks, at some point everything gets shut down. I'm not exactly clear why it is. Unicorn Sprinkles, happy Tuesday. How you doing? Mr. Giggs, hi Leo, how are you? Doing very well. Well, I wish I were doing better. Yet another cold, so feeling under the weather again. I'm so sorry. I hope you're feeling better. It is the season, you know. Myself, I think we need to go out and get those flu shots. Tend to work pretty well, at least for me. Haven't really been terribly sick every time we get those flu shots. So I'm sorry to hear you're not feeling well. Hopefully you can hang in there today for the conversation. I think all the sound is good. Everything audio is fine. Outstanding. Remember, if you want me to read out your comment, answer a question, just put the @YouTuber Law before your comment, because on my end it puts an orange box around it, so it tells me to read it out. You don't have to use super chats, obviously the topic of the conversation. For me to read it, you just have to put an @YouTuber Law and I will read it out and respond to it. So super chat just puts a big box around it, so I jump to it and I read it out ahead of the other streams. But if you just put an 'YouTuber Law, if you're not sure if it's one word or two, very easy. Just put in the symbol @ and then a YO, and it will actually pop the name of the channel above it, and then you can click on it, and it should repopulate and create that orange box. So as we always do, I'm going to start by doing like a 10-minute kind of conversation, kind of lay out the structure. As you can imagine, we've spoken about this kind of idea before, but I want to lay out all the different argument for or against any sort of legal liability and who might be potentially liable under this. So just to set up the discussion going forward, so we don't have to repeat the same argument over and over again. So that's what I'll do in the first 10 minutes. And then I'll go into all the comments and questions. So you've got anything, just throw it in there, because I will jump back in and I will take a look at everything you guys are writing. Mr. Giggs, the doctor said I can't really have a flu shot while I still have a cold, trying to shake them, but I keep getting them, just my luck. I think I heard that before, that you cannot get a flu shot while you're still sick. You got to get better. So good luck. Critique of corporatist ideology. Can we pin the blame on mundane Matt? You might, given the history of that channel, you might be able to. I have to tell you, I haven't looked at a single video since all that stuff exploded. Really wasn't watching much of his stuff before that, but that was pretty much the end of everything as far as I'm concerned. But made for a very interesting topic for quite a while. So let's start the stream and start the conversation. Excellent. So let's what I'll have to do here is just start the conversation, discuss what's going on here, and discuss mainly 5 different potential legal options here and questions that are being raised by what has happened lately. So quickly, back in May of or June of this year, BuzzFeed did an article saying that the alt-right is using super chats within different live streams to highlight their messages, mostly hate and bigoted, racist kind of statements. And they brought that issue up into the media, that then actually took their story and brought it to YouTube. YouTube looked at it and said, well, we don't think the channels are doing anything wrong, though we see that the comments are in violation of our terms of service. We're going to look further into it. You can probably credit that original BuzzFeed article to some of the later discussions that came up in the last few weeks. We had that discussion in a video about 2 or 3 weeks ago. I'll leave a link up above if you're interested, about whether or not YouTube is permitted to divert funds that are attached to racist super chats or any super chat that is in violation of the community guidelines. Are they allowed to divert it, not give it to the content creator on whose stream it is actually paid, but rather divert it and give it to a charity? That was a big topic a few weeks ago. Nonetheless, in the meantime, the Wall Street Journal came up with their own article. For all practical purposes, a rehash of what BuzzFeed did back in May, except in this time they actually are naming a specific channel, kind of making it an example. They're naming the Ralph Retort Killstream, saying that on this stream they're not really attributing the channel itself to any sort of political affiliation, though they're saying that it is a far right. They're not saying alt-right or anything, but they're saying that through the stream it becomes kind of a megaphone to some of racist and alt-right ideology through the super chats, because not only when you purchase a super chat is your message highlighted, is also pinned, mainly it hangs longer within the chat itself, and then the content creator in this case did actually read out some of those messages, which kind of amplify the message and kind of fed on what BuzzFeed said a few months earlier, that the alt-right is using super chat as a way to amplify their messages on popular live stream. The Wall Street Journal then took the story to StJude. No, sorry, I'm skipping one story ahead of time. So in the meantime, while this is going on, the Ralph Retort decides to use the power attributed to it through the different articles for some good. It says, you know what? Instead of taking the money ourselves, benefiting from what the articles are saying is racist messages, we are going to divert today's live stream to a specific charity. They chose StJude, a great charity by all accounts. The live stream went live, and during the process they raised $26,000. Very commendable. But in that stream, as part of that fundraiser, there were at least identified, because I didn't actually see that particular live stream, identified lots of racist and bigoted statements, basically a lot of it feeding off of the shooting that happened in Pittsburgh a couple of weeks ago. That story, the Wall Street Journal then takes that particular story to StJude. StJude saying, we're not interested in the money contributed through the live stream. We're going to work toward refunding or rejecting those funds. YouTube actually starts the refund process when the story gets to them, and very shortly thereafter terminates the channel. The question is, okay, was there any sort of legal problem in this entire process here? Is anybody to blame here? Is it something that the law can take care of, or is this really just a reality of what happens when you're operating on a private platform subject to private rules? That's what I'm going to try to answer in what hopefully will be a very quick overview of the different issue. I chose 5 specific issues that I saw people repeating over and over again on very popular videos online, and I want to address each of one of those directly. So first one is defamation. The claim is that the Wall Street Journal defamed this particular channel, the owner, the Ralph Retort Killstream channel. Is that true? Or maybe it was StJude or YouTube. Did any of these parties defame the channel itself, or maybe the people that are actually writing the super chats? Well, let's just dispense with the people that were writing the super chats, since they were never identified by any of the parties. You could not defame people by actually never identifying them individually. So nobody defamed the people that contributed any particular statement as part of their super chat. Now, what is defamation? It's a statement of fact that hurts somebody's reputation or financial well-being. So you'd have to go through the article, and I've read that article a couple of times, and as far as I can tell, there are no false statements of fact that otherwise would directly contribute to a financial loss. There are statements of fact in there, largely attributable to whether or not statements made on the stream were racist or bigoted in nature. That would be a statement, that'll be a true or false statement. And the other ones will be more in line with whether or not the channel itself moderated those statements. The article claimed they never moderated them. Not only did they allow them, they encouraged them, but actually read them out loud. So those are statements of fact. So if any of those are false, that might be the basis for defamation. I don't believe those particular statements are false. There were a lot of other statements being made on the article, but in my opinion, a lot of those were opinion-based statements. There weren't really factual statements. For instance, calling the owner of the channel far right, that is more of an opinion. That would not be considered a statement of fact. He might as well have been completely a liberal. It doesn't make a difference, because you're allowed to express an opinion even if it's completely false. So as far as I can tell, by looking at the article itself and just looking at, okay, this will be statement of fact, this will be more of an opinion, I don't see the basis for any sort of defamation. People use the term defamation to say something more colloquially about you harming his reputation, but don't forget that any statement that is otherwise true is an absolute defense to defamation, and also any opinion is permitted. It's cannot be the basis for defamation. Second one is the question of free speech. Lots and lots of videos focus on whether or not this was a violation of free speech. We spoke about it many times. Free speech is a right you have against the government. It's not a right you generally have against private parties, right? It's the government that was always seen as the big enemy of the people, big enemy of free speech. It was the government. There were a lot of part of what was built into the American Revolution, actually started pre-revolution in the colonies, is an objection to different rules of behavior and speech and the press imposed by England. It built itself up, but we talked about it many times. Modern day free speech rights really developed starting in the 1920s and through the 1960s, and it's always against the government. There is an exception, and that's when a private party takes over duties traditionally reserved for the state. And an example of that, a traditional example being used, is a corporate town, a company that runs an entire town. It owns the street, it owns the post office, it owns the transportation, it owns virtually everything. A company that runs the entire system effectively takes over the role of government, and as such is obligated to provide certain rights like free speech on its premises, basically allowing people to, let's say, protest on the street. So the right of free speech is not something you would find to be a violation here. People colloquially call it the right of that our free speech is violated because they think of themselves, well, I'm permitted to say whatever I want to. True, but that's vis-a-vis the government. The government cannot stop you from saying things. That's why up until a few years ago, people said a lot of terrible things on YouTube, on Facebook. We had terrible videos that were produced and organized by people committing terrorist activities, killing American soldiers abroad while we were actually in the midst of a war, and the government could not stop it. It would be up to the private platform to do it. For a long time, they weren't interested in stopping it, because ultimately the government cannot stop our ability to speak except for very, very specific situations. And it's up to the private parties to govern exactly what kind of speech they permit on their platform. And that's really it. It's a private platform. They are permitted to establish their own rules of what they permit or not permit here. Number 3, which is a question was sent to me, it was posted in the comments, people have been talking about before. It's the concept of a public square. The idea being that places like YouTube, Twitter, Facebook now take over as the modern day public square. You're like walking into a park and expressing your opinion. The problem with that is, how is this going to turn into a public square, right? How we take what is otherwise a private platform and turn it into a public square. One idea many people propose is for the government to effectively assume control of the public square as they see it. The problem with that is that there is a process by which the government can actually take over what is otherwise private property, right? Because the Constitution guarantees us that you cannot take property away absent some sort of a fair compensation. So effectively, for the government to take over YouTube and take control over it, because it now becomes a public square, they would have to buy Google. They would have to buy Facebook. I'm not sure if the government has the wherewithal to actually do that nowadays. The other one is through eminent domain. There, they can actually declare that, just like land, when the government wants to build a bridge and they need to take over your land, that through eminent domain, again, they actually have to go through a process, either through an agreement to pay you a fair price, or if not, essentially sue you. A very unlikely process. The two other ways are basically through nationalization, which is not something you're going to find in the United States in modern times. Yes, we've had some blips on the radar of those kind of things in the past. You're not going to find anything like this in modern time. There's also arguments that during certain times, like times of war, the government can come in and for the sake of national security can take over some private companies. Not really applicable here. The other argument is that, well, it's not the government taking as much as, let's say, Google giving, right? There was a lawsuit that said basically, since Google actually was promoting YouTube as basically a public square, is a place where free speech was promoted, as a place for everybody to come and express themselves. Effectively, they dedicated their platform to the public as a square. The courts threw that completely. There's almost no chance of that happening. You cannot essentially give up your private rights by just using some basic marketing and promotional language. There are actual things you have to do to accomplish that. There are legal hurdles involved in you actually dedicating what is otherwise your own private land to public usage, and that would be subject to certain public rights like free speech. So when people are pointing to the way that YouTube has characterized its own platform, including Twitter and Facebook, that kind of an argument has been basically so far has been rejected, unlikely to be accepted. Marketing speak is not going to be enough for you to then lose rights to your own property. Fourth argument is discrimination. They're discriminating against us. Well, now you have to figure out what is us. You know, if the us is our ability to express bigoted and racist ideas, that's obviously not going to be a protected class, and nobody is going to be fighting that war for you. So people say, well, no, this is part of a larger war against the right, a war against conservative and maybe the far right. Now, that's an interesting argument to have, except that political affiliation and expression is not a protected class. Now, which means that unlike race, sex, nationality, age in some cases, political affiliation is not something that U.S. laws right now protect against. So effectively, yes, you can discriminate. Private parties can discriminate against you based on your own political affiliation or political expression. Now, there are some states that have political affiliation or expression as a protected class. DC has it as a political affiliation, but that's discrimination based on what political party you actually belong to, which wouldn't be really the issue here. It's not a question of what you belong to. We're talking more about expression than political affiliation. That there are two states, I believe it's California and New York, but don't hold me to it, that have political expression as protected classes, but those are limited only to employment, basically so that an employer cannot retaliate against an employee who is expressing his political affiliation, or let's say wants to support a candidate that the employer is against. So it's very limited applicability. So unless something changes, unless states decide to adopt political affiliation, or more likely political expression, as a protected class, you're not going to see any lawsuit involving discrimination. And the fifth is antitrust. Basically, only in the last couple of days, Donald Trump said in an interview that he is directing the Justice Department to take a look at some of these companies for antitrust violation. Of course, the next sentence he said, but then you're getting into first free speech problems. And that's true. I mean, at the end of the day, many courts have held across all the federal circuits that these companies, in their what is otherwise seem to people to be discriminatory decisions, in their ability to promote, demote, monetize, demonetize, cancel, or uplift certain channels or speakers, they are expressing their own right of free speech. So it is absolutely true. There's a problem with an antitrust based on companies expressing their speech. But nonetheless, when we look at antitrust, there are two potential issues there. One is collusion, and the other one is a monopoly. Neither one is illegal per se. It's not illegal to collude. It's just illegal to collude in a way that it's anti-competitive. It's not illegal to be a monopoly. It's illegal to act as a monopoly in a way that harms the consumer. So collusion. You'd have to make an argument that several parties, including the Wall Street Journal, maybe the media and the platforms, and maybe even the charities, colluded to kill this channel. That's a very, very hard argument to have, because you'd have to argue that the Wall Street Journal effectively is concerned about competition from the channel, and they're not competitors. Is killing the channel somehow a knock to competition? No, I mean, effectively, it's not. It's a knock to that one channel. It's important to that channel and to its fan, but unlikely to be seen as an anti-competitive act in and of itself. And an argument that somehow it's competed with YouTube, that's been tried before. The argument being made that the channels themselves are also competitors of the very platform on which they're on. That so far has not worked in the courts. The second one is monopoly, but monopoly, to show that somebody as a monopoly acted illegally, you'd have to show that they effectively harm the consumer through a pricing mechanism. The courts only look at really harm to the consumer through a pricing mechanism. In this case, there is no price. The platforms, all these platforms are free. There is real problem in trying to win those kind of cases. There is a case that's right now making its way through federal court. We discussed it a few months ago. It's a relatively weak case. It discusses antitrust, but now really flushes up some of the problems I just discussed. And as a result, the likelihood of it succeeding is very small. So who is responsible? You don't have to like it. You don't have to think that this is the way you would run it. You don't have to appreciate it. You might wish that more and more of these platforms were beacons of true free speech and would not actually censor any speech based on its own content, but the reality is that you are putting content, your own personal content, on a private platform subject to private rules. And as long as you do not, if you violate those rules, you are subject to their termination, demotion, demonetization, or anything else they choose, because ultimately, in so doing, they are expressing their own free speech, including their idea that, no, we don't want to have a complete free speech kind of platform. That's their own expression. And under the current laws that we have, there is no illegality here. So as much as some of you may not like that answer, or don't like the fact that this happened, or that platforms are actively removing speakers and topics from their platforms, the reality is that those actions are proper and they're legal. Not proper in the sense that I support them, but proper in the sense that they're legally proper. They're not not permitted, and that's why we've seen time after time every single case against this platform to have been lost. Anyway, I definitely spoke way too much longer than I actually wanted this. So let's jump in and take a look at some of the comments. Remember, just put an @YouTuber Law in front of your comment. I'll read it out. Let's talk. Luis Campuzano, hello. How you doing, Luis? Mr. Giggs, now that Killstream has been removed from YouTube, what is YouTube's obligation in regard to outstanding AD Super Chat revenue? That's interesting. Good question. We spoke about it a little bit in the prior video. I believe it was about 2 weeks ago. I believe I left a link up above to that original video that discusses YouTube in its legal documents, in terms of service and through its AdSense, because everything runs through AdSense, any sort of revenue, defines Super Chat as a product, a digital product that it provides you. It is absolutely, the way they define it, not a means by which you are providing money to the content creator. That might be your intention, and there's some proof that they've actually marketed that. I mean, some of you have showed me some of the hidden language within it that shows that this might be a way that they are trying to promote it as a way for you to give money to the content creators. But they are at least attempting, whether not successful or not, to say that the Super Chat is a pure product that they are providing that you essentially acquired the minute you click enter. I mean, you pay the money, you put your chat in, you get exactly what you paid for, which is your content pinned and your statement, your chat pinned, and in whatever color that matches the amount of money that you got. Now, since you get exactly what you paid for that moment, if it doesn't make its way to the intended content creator or even the charity, that's irrelevant from your perspective, because they are not they provided you with full product, the actual product that they wanted to sell to you at the moment you clicked return. So they can do whatever they want. At least that's their legal position. Effectively, what's happening here, they can always return it, essentially give you a refund on your product. You got the service you paid for, but they can always refund it. So in them refunding it, they're absolutely within the law. They can always refund it. Remember, there was a legal problem with them diverting funds. I have an issue because the way their terms of service are written, that I don't believe that they are allowed to actually divert funds that are paid in, because the way their terms of service are written, they have an obligation to transfer funds the minute they are in receipt of it. So to the extent to which money is received by them and they keep it, they are obligated to actually transfer it to the content creator. But in this case, they are actually refunding the full amount back, so they don't really have to do anything. Don't forget, they also did it because the charity StJude rejected it. So they're not obligated to refund it. StJude can actually reject it, and YouTube can keep it and do whatever they want with it. But YouTube obviously refunded the whole thing. So the answer is there is no obligation, to the extent to which they submitted any funds or any chats paid out during that particular live stream, and another one that I believe they did afterwards that was shut down in the middle, they refunded it, so they have no particular obligations against it. Can they go back, look at money paid out and before? Yeah, but they're not going to. They don't have a mechanism by which they can actually go back, take a look at accounts, what they paid, and actually get their money back. So it's really, unless they're holding on to money that is belonging to the channel and that they didn't refund back, that's the only time there can be an issue. In my opinion, they can't divert it. They have one choice. They can either pay it out to the channel even though they terminated it, or they can refund it back to whoever actually paid out those chats. It's the only two options they have. Big Yehuda, I'm really tired and want to sleep. I just wanted to wish you well. Thank you so much, Big Yehuda. I appreciate it. Unicorn Sprinklers, don't forget to click likes. Yes, guys, please. Thank you so much. If you can just click like that, really help. Trey, thank you, YouTuber Law, for covering this. You've always seems to have an even head about these issues. Appreciate that. Thank you so much. I try not to get into the drama. There's a lot of things online that happen that affects us all, things that I don't like. I personally would have loved to see more and more of these platforms allowing for free speech, and I want them to give us the tool to choose what to listen to, because while you have a right to say what you want to, I have a right not to listen to it. So I would have liked things to happen differently. I'd like people to encourage free speech by allowing people to control, but that's not the route they're going at. But my goal with everything that I do on the channel is to try to provide some measure of sanity when we're looking at topics by focusing on what the law is. So I try my best not to define what I speak about in terms of my own personal political beliefs. And the reality, I told you many times, I really have very little interest in politics myself. But it's all about the law, and I think that sometimes when we see it from the legal perspective, we can see it through different eyes than necessarily our own emotional attachment and how it impacts us. Anyway, that's the thought behind it anyway. Eric Ahim Ezel, I hope I'm pronouncing it correctly. Is it possible someone could argue that the channel could be seen as partners of YouTube and that they have a contract and thus responsibilities? Apology if you covered this already. Don't apologize. It's a good question. We've had at least one case that tried to cover that one issue, and actually there's two different cases. So there are two specific things you're looking at. One of them is whether or not, if I am on the platform and YouTube itself is a content creator, because YouTube actually creates its own, whether or not, since we are not only residing on the same platform, we are competitors, whether or not, you know, the action of one can actually harm the other. Mainly, is YouTube actually harming me because I'm also a competitor? That has been tried and it failed. The other one is looking at purely from a contractual perspective, right? That not necessarily a partner here, but that I'm somewhat of an independent contractor. Some people tried the concept, almost calling it an employee-employer relationship. Am I, as an independent contractor, are they obligated to me in certain ways? That has failed largely because the courts have looked at it and said, you know what? Section 230, we haven't spoken about it here specifically, but it's a Communication Decency Act. It's the reason why platforms effectively are allowed to demonetize you, to basically remove you from the ranking, to push you into restricted areas, to terminate your account, suspend it. They can pretty much do whatever they want to. They're allowed to manage to effectively control the platform as they wish without any reliability. It gives them that umbrella. It's a law that was passed back in 1996 and has been approved, have been supported and by just about every federal court and now state court for these past 20 years. So the idea is that if the way the courts have seen, when you're trying to rely a lot of times about the contract rights, you're often trying to get around Section 230. basically saying, well, I have a contract with them. As a result, they are not permitted to do that, but the law permits them to do those kind of actions, like actually remove you or demonetize you or derank you. As a result, you cannot rely on the contract side of it, what you're calling partnership, as a way to get around Section 230. So that traditionally has failed. Now, there was a case where the court actually looked specifically into whether or not the contract allowed them to do what they did. And that was the case of Jared Taylor in California. It was a low-level case in state court. And I told you at the time, it was a bad decision. The judge did not understand the way the law actually works. It was just wrong. The judge actually asked the question, well, if YouTube decides tomorrow to not allow women on the platform, that would not be legal. And the attorney, oh, she was Twitter, sorry. And the attorney for Twitter said, well, we would never do that, but yes, that would be legal. Now, it sounds awful, but the attorney is correct. The judge was wrong, and it actually was reversed on appeal. You cannot use, just because there's a contractual relationship, in a sense, you cannot use it to get around what was otherwise Section 230, because here, private platforms are allowed ultimately to discriminate. Yes. Why? Because they are allowed to discriminate based on a lot of reasons, like in this case, political affiliation, political speech, or just speech in particular. And even though it sounds awful, even to some judges, it's absolutely true that that the law protects them and provide them with kind of an umbrella against that. And while the judge then tried to refocus and say, well, no, the contract between them actually is unconscionable because there were certain provisions that should not be permitted, like the ability to change terms in a contract at any time as they wish, that would be unconscionable. The Court of Appeal recognized that this was just a way of trying to get around the umbrella protection against any sort of liability that Congress intended these platforms to have for the past 20 years, and it was thrown out. So it's a good question, but so far it has never succeeded. You'd have to find a specific provision that was otherwise violated. And since all of these contracts ultimately have in them the idea that I can terminate you for any reason whatsoever, even if I don't know about that reason now, I haven't even thought about it. And as long as that idea is being upheld, and it's been upheld just about every court, in every court across the land for the past at least 10 years, there was a time when some of those provisions were not really upheld. But the idea that I can have that kind of provision negates your ability really to argue that I can't terminate you. So yes, there are times when you are not permitted to do something. For instance, the super chat, diverting super chats. I would argue that unless they change their contract and the way they handle super chats through AdSense, they're not permitted to divert super chat because they feel they want to give the money to a charity. That would not be legal. So in that case, I would say yes, there's obligations in a contract and they're violating it. But when it comes to terminating you or demonetizing you or deranking your videos or your chats or making sure that nobody else in the world actually sees what you're saying, that itself is not going to be one based on the contract or rights. And just about every court has seen it that way. John Ferguson, how you doing? YouTube could demonetize the channel instead of pulling it down. They can also disable super chat. They're jumping to censorship too quickly. I agree with that. I mean, and I tell you, something changed, and I can see it from their perspective here. When BuzzFeed did their original article and YouTube looked at those original allegations, they said that the channel did nothing wrong, though the chats were in violation, and they did absolutely nothing. What changed here, at least what I've been alleged to have changed, because again, I didn't see the actual stream, is that he read out those chats. It's not just that those chats actually showed, because at that point, the proper remedy would have been demonetize, take away the ability to super chat, which would be a reasonable way to do it. because somehow, whether or not it's him specifically or the people following it, the chat is then in violation of their community guidelines. But I think that once he read out any of those, he then himself violated the community guidelines, which gave them cover to terminate the agreement. So I'm complete agreement with you, because if had they actually demonetized him, there would be no longer an opportunity to do it. But I think that what they hung their hats on is the idea that he read out those chats. As a result, that's his own action, and that will be the basis for termination. Oh, ER $10. Thank you so much for the super chat. I appreciate it. Mark Wade's motion to dismiss paragraph 5 said that he didn't engage in any conduct involving Mayor while in Texas, but is on the record at Texas Comic Palooza publicly speaking about Mayor. Is this perjury? Not necessarily. Again, I haven't read it. But that's not necessarily perjury, because there are opinions and they differ across states and across jurisdiction of what it means to actually engage in business in the state. And is it directly related to the action at hand? Is it something completely unrelated? It's something you do once in a while, but you don't really engage regularly. So that itself is not perjury, unless he specifically said that he was never in Texas. He never attended any sort of event in Texas, so probably not perjury. But I have to admit, I haven't really read that particular opinion, his response, so I'd have to look at it. Mr. Giggs, what about any adverts or super chats funds outstanding from previous streams video? Do you get paid out every day or every 30 days? Streams not directly affected by these issues. No, you get paid out on a monthly basis. It's just like anything else. Basically, it's AdSense. So AdSense pays you once a month. There's a cycle, and it pays you everything. And you have to understand it is because it's based on YouTube's ability to collect and also incur any sort of chargebacks when people call their credit card company and says, I never made that payment. So they basically wait until the money's in their hands, and then they have some guarantee that there's less of a chance of a reversal of the charges and stuff like that before they pay it out. So you do a super chat today, chances are the content creator will not get it until the end of his 30-day cycle. That could be tomorrow, or it could be in 30 days. It kind of depends what day of the month it falls under. Eric Haim Azel. Sounds like it could be a slippery slope, but an understandable one. And as for the name, you got the first and last right. The he, him is just my way to get my pronouns out there. Oh, very cool. I'm assuming need a cute Asian girlfriend. That's a nice thing to wish for. Are ISPs considered platforms? That's really, really a great question, because a big part of this issue resides in Section 230 of the Communication Decency Act, which at that time was 1996, really focused on, I wouldn't even say ISPs at the end of the day. These were service providers that at that time they allowed entry into the internet, but basically were, as far as we're concerned, were their internet. This is CompuServe time, Prodigy times. This is before we had our traditional ISPs the way we know it today. This was, more like America Online was, if you're old enough to remember America Online, but it's in early days where people went on American Online and they thought that was the internet, and often never. Yes, if you wanted, there was a button to get out to the rest of the internet, but pretty much it was the internet for people. So it was a very, very different world. But over time, courts have interpreted the law to include these platforms. So yes, pretty much the way the law was written, and you can argue that, well, it was just something that made sense back in 1996, and it makes no sense today. The way the law was written, it says pretty much as long as the online service allows more than one person to simultaneously engage the server, that pretty much is, that's pretty much of a covered service provider. Now, I said it before, I think in 1996, that idea was monumental. How many companies could actually set that up? Now, it was like CompuServe, the big companies of the time, the America Online. The idea that nowadays just about everybody can set up a website, and which means by definition that more than one person can actually enter that website, pretty much mean that virtually everything online is really a service provider that would be covered here. So yes, those platforms under the definition are covered by Section 230, and pretty much anything is. And there might be a reason why Congress should go back and revise and take a look. I'm never opposed to us looking back at old laws and seeing if they still make sense. But the reality is that Congress has not done anything productive in how many years? I mean, I'll be hard-pressed to think of anything particularly good that happened by Congress in the last 20 years. Maybe a handful of laws that have actually been useful. That's the reason why the approval rating for Congress is so low. So the idea that they would actually go back and look and see, well, the law from 1996 doesn't really make sense, let's try to redefine it, is it's really a relatively small chance. John Ferguson, I think that it's important to recall the impact of the Skokie decision allowing the Nazis to march through town. Many laws were passed at both state and national level in response. I agree. I mean, you have to understand that I immigrated to the country in 1982, and my recollection, I mean, of actually learning about this country was in civic class, right, in public school. And the only thing I can ever recall coming out of that civic class, the only thing I can recall out of high school, really, I don't think high school is particularly a productive environment, was the Skokie case. In my mind, Skokie was America. That was what made America great. It's the only thing I recall from anything in high school. And it was basically the Nazi Party wanted to march through, well, I don't believe originally they designed it to be in Skokie. I believe they originally were thinking about doing it in one of the larger cities. They were rebuffed. They decided to do it through Skokie. Skokie was a residence place for not only many Jews, but also many Holocaust survivors. Skokie didn't want anything to do with it and tried to stop it. Both the state and the city wanted to stop the Nazis from marching through town, largely based on the harm it would do to the residents because of this obviously the special sensitivities of the Holocaust survivors. And it made its way through the court system, never made it really to the Supreme Court. It was never accepted. The certiorari was never accepted. As a result, the Court of Appeal was actually affirmed. The idea is, no, the state cannot stop offensive language, no matter how much it would hurt individuals. It has to allow it. It has to allow. There are obviously certain accommodations that states are permitted, cities are permitted, including, you're not allowed to stop traffic. You're not allowed to, you might be able to be restricted in where you can protest to specific areas. They have to be very, very careful so that those restrictions are not actually intended to stop speech, but rather there's certain logic behind them in order to protect the city, let's say, from traffic stoppage and maybe even, people getting the grounds dirty and stuff like that, or not doing it across from people's homes, doing it near parks. There's a lot of things a lot of reasonable restrictions that cities can place on everybody, not necessarily on one group. And that was a monumental look. I mean, you have to understand, again, our modern day sense of free speech, really not from the 20s, through the 60s, and this was one of the seminal cases on it. No, the state cannot stop you from speaking, no matter how hurtful it might be on the person hearing it. That really is not the state's concern. The state should be concerned with your ability to speak. The problem here is these are private companies, and you are doing this subject to private rules. Through our usage, we feel that we are entitled to certain rights on these platforms, but unfortunately, those platforms don't lose their right to free speech, because they are speaking through their rules, or their right to make decisions on how to govern their own rule. They don't lose that just because we love their platform, we utilize them, we rely on them for our own livelihood. They don't get to lose that, and can't see the government coming in and taking over and claiming that somehow these are public square. There is no basis for it, and after all, the government would have effectively to buy Google in order to do that, and I don't think that's realistic. OWM, YouTube has the best of both worlds. 230 protects YouTube from being liable from individual posts, and the First Amendment allows them to act as a publisher in that they can boot out the opinions that disagree with YouTube views. This allows YouTube to be a publisher while claiming to be a platform. True. Beautifully said. And that's what the law says exactly. That as of 1996, when it comes to all of these platforms, this dichotomy between being a publisher and an editor no longer is relevant. It's relevant to the New York Times, the Wall Street Journal. If they accept, every time they accept any sort of third-party opinion, they can potentially be liable in the case, let's say, of defamation, of something like that, because as a publisher, they have certain publisher liability associated with the content that they publish. That's not applicable to these platforms because that's what Congress wanted. People often think that that this is somehow happening contrary to the wishes of Congress. False. No matter what politicians tell you, Ted Cruz is wrong, and he knows he's wrong. It's completely contradictory to what Congress did. Congress wanted these platforms to manage, to police themselves, to create more family-friendly atmosphere. They didn't want these platforms to be liable like a publisher of a newspaper. So Congress specifically granted them this right, so they would then go out there and create a safer environment. You have to attach that section to the Greater Communication Decency Act, which was later found to be unconstitutional, so was thrown out. But Congress tried to control speech on the internet. They tried to make it liable that when you are saying certain things on, let's say, you are in Texas and you are saying something that somebody in Ohio might be offended by, you'd be liable for it. And the courts threw it out saying, well, that's unconstitutional. Don't think for a second that Congress was your friend here. What you got is exactly what Congress wanted. They wanted you to be able to, they wanted there to be a more family-friendly online world. They just had to learn the hard way that they can't do it themselves by passing laws, but they could do it by granting immunity to private parties, and the private parties can then do what Congress otherwise could not do directly. Otaku Reborn Podcast. I was wondering your thoughts on someone not changing under fair use law, i.e. DSP who barely adds commentary would still be considered fair use. There is no easy way to answer that. Fair use is one of the most difficult subjects you can think of when it comes to actually giving an opinion. So anytime somebody looks in a particular, let's say you created a work of art and you took it to a lawyer, he may tell you an idea whether or not some of the elements you use, let's say you borrowed it from somebody else, is fair use or not. But it really is just an opinion, because the way the law is set, well, the law says you have 4 different elements to take a look at. the court is not obligated to do anything with those 4 elements. So it's really up to the judge to make his own determination about whether or not the fair use elements apply here. So what we have are some cases where the person using somebody else's property did absolutely included, let's say, 100% of the work, and it was considered fair use. And we had times where somebody included very little and it was considered not fair use. And then how much commentary? Well, there are lots of lawsuits, and we can see patterns, but we cannot answer anything definitively of how much do I have to do for it to be fair use. Ultimately, we're looking at transformativeness. The 2 big, out of the 4, the 2 elements being transformativeness. Did you transform it into something that it wasn't? Largely, we're looking at something like parodies, where you took somebody else's work, you wanted to make a commentary on the world, or you wanted to make commentary on the work itself through commentary or satire. Parody or satire. And the new work, the transformative work, is your own contribution, and your usage of it is basically secondary. It enabled your commentary. That's traditionally what you look at as transformative. That's why something like what Sargon did was transformative, because ultimately he commented through the rearrangement of the parts. We talked about it before, I think, but his particular case, somewhere where somebody adds seems like it adds very little, but in that very little, he made a statement. And basically, by just chopping somebody else's video, putting it together, creating a new title that is otherwise critical, but effectively you would think did very little, yet still create a statement that is otherwise wholly different, transformative from the original content. So you can do very little and still do it, but there were times where people added a lot and still was not fair use. There were we reviewed that cases before. There were cases where you took a company took traditional novels and basically created small summarization so children can actually understand them. So they created children's version of long. So you took something like The Catcher in the Rye and created a children's version of it. A lot of work, enormous amount of work, and it was copyright infringement. It was not transformative at all, and we don't have to get into it. So you have a mess of a law that's very, very difficult to actually give an answer to. If I had something in front of me, I can give you my opinion on it. But even then, it could be completely contradicted when a judge looks at it and looks at it a little differently. Unical Sprinkles. For him to see your question, type at YouTuber Law. Yes. Guys, I'm not rejecting any of your comments. I'm not skipping over them. I'm only reading anybody that put the term at YouTuber Law, because that gives me an orange box. That's what I'm reading. So if you put any comment before and I'm missing it, just put at YouTuber Law, and I will see your comment. Guardian Angel. If you get a chance to go into details about the motion to dismiss Mayer versus Wade, I'd really be interested. It's always good to get an outside look at it. Yeah, obviously I did a video on the original lawsuit. I haven't revisited now with the response. So I think I will either do one as a recorded video, or I will bring it up as a topic for next week. You guys can vote on it. Might be actually a good one for next week. I already have one topic that I want to bring about the very interesting case, but maybe I'll just put that up and see if you guys are interested. So for next week, I just haven't had a chance to, I kind of skimmed through it, so I haven't yet developed a whole notion of a response for it. So I'm all for it, but I'm not really prepared to respond to it today. I think that we're good. Today was a shorter live stream. Thank you very much. I think, let's see. Thanks for letting me know I was interested. Otaku Reborn podcast. Excellent. Guys, thank you so much for showing up today. Thank you so much for talking love talking to you. Your comments always interesting, always challenging, always trying to figure out something new, and I always learn something. And trust me, every time I copy all of your comments, I look through them, and I always learn something from everything you guys have said. So thank you so much. If you have any questions, any concerns, anything you want to discuss, just leave it down below. I'd love to talk to you. I'll see you next time.